sit a bit closer, Lord.
A bit detached, we thought.
Well, good morning. This morning we're taking evidence for the United Kingdom's three law officers. The Right Honourable Victoria Prentice, KCMP, who is the Attorney General and also the Advocate General for Northern Ireland. Michael Tomlinson, KCMP, who is the Solicitor General, and Lord Stewart of Delfin, KC, who is the Advocate General for Scotland. I should emphasise that the word general in your titles is an adjective and not a noun. But nevertheless, they're very impressive titles and carry big responsibilities. So thank you very much for coming to see us this morning.
Thank you for having us.
And we look forward to hearing from you. I'm going to start with a quite general question. I'm going to take you in order of as I presented them, with the Attorney first, Solicitor next, and Advocate General third. And if I can put this question to you, first of all, I wonder whether you can tell us whether, as a law officer, you consider that your duty to the rule of law has a greater priority than party considerations, bearing in mind that you are a member of a party as well as a law officer.
Yes, is the short answer. I consider as a barrister that my first duty is to the court. I have always felt that way since my call. And though I do have other, sometimes competing considerations, I have duties to my constituents, for example, in Banbury. I have duties to my party. I have duties to the government, of which I'm a member. I definitely feel, particularly in this role, that there is no question but that my duty to the court comes first.
And how does that play out in practice? If an issue arises, for example, the obvious problems arise under the European Convention on Human Rights, and issues may arise as to whether or not what is being proposed is compatible with the Convention rights. How do you go about that task?
Well, that goes to the very core of what it means to give the government legal advice. Not all of the advice we give is welcome, and it's very important that we are able to help government ministers into a position of compliance with both domestic and international law to make sure that the legislation that is prepared by government is appropriate, and to ensure that the government litigates properly before the courts. That is at the very core of all of our roles. It's a job that we do together. We are particularly keen, when the advice is controversial, if I can put it that way, to act as a three, and we give our advice together where possible. We might follow that up, the written legal advice, we might follow that up in conversation or in private conversation with ministers in government. But we try to make sure that our advice is clear and that there's no dispute as to the boundaries, if you like, of that advice. Of course, a very important part of the role is that we can help the government come up with solutions that make sure that the proposed course of action is perfectly proper and within the law. So we may well have ideas and mitigations and other ways of dealing with the problem, which mean that the situation proposed is a lawful one.
Yes. Well, we may explore in more detail later on, but of course the problem arises where the government says it's got a red line, and you realise that you're coming right up against the red line, and there's a real issue as to whether or not that line should be crossed.
That's at the very core and heart of the role of Attorney General. You're not here to be popular, and you have to be able to say no where necessary to the government generally, the Prime Minister and other ministers in particular. That is a very important part of what we do. It's also, if I may stray into my own history, at a very important part of what government lawyers do. And as you know, Lord Hope, I was a government lawyer for the vast bulk of my career. I do think that government lawyers have duties. We have the AG's guidance, which sets out what those duties and responsibilities are, and we need to make sure that the government is complying both in legislation and litigation with the rule of law.
Yes. Solicitor General, do you have anything to add to what's just been said?
I don't think so. The straightforward answer is yes. Our role is very different from other ministers. And of course, in much of what we do, much of what I do, that the Attorney kindly delegates to me, is very much not of a political nature in any event. Yeah. I'm thinking in particular of the public interest work that inevitably ends up on my desk. That is absolutely not in the political domain, if you like. But we are both politicians. I'm an elected politician for a particular party in my particular constituency, and I suppose it's that tension that makes the role quite so interesting.
As far as organisation behind you is concerned, you share a department with the Attorney, are you? You're really in the same department with the same officials behind you.
Exactly right, my Lord. I regard myself as the Attorney's number two. Whether she regards me as that, I don't know. But I very much regard myself as a deputy to the Attorney General, and the Attorney, in terms of division of labour, very much encourages me to do the public interest work, unduly lenient sentences, consents to prosecute where the Attorney's consent is required, and the like. I describe it as much of the paperwork which ends up on my desk.
Yes. Now, Advocate General, I've understood that you're part of the team as well, but do you have a separate department, or do you share officials with the Attorney and the Solicitor?
There is a degree of overlap in the sense that we see the same officials at our regular law officer meetings, for example, and we receive input from officials, as the Attorney and Solicitor do from time to time from my officials in relation to particularly Scottish aspects. If I could come back to the question that you posed originally to the Attorney General, I think that from a political standpoint, I'd like to echo the Attorney's words about the collegiate approach which we found it useful to take. And my position is, of course, different from my two law officer colleagues. I do not have a constituency. I was appointed to my post. I was not in frontline politics in any capacity before I came in. That, together with the fact that I sit in the House of Lords and so exercise a law officer function in your Lordship's House, I think augments the strengths of our collegiate team because it brings a set of different perspectives. Similarly, our different experiences at the bar are complementary. The Attorney has already mentioned her government legal background. My background for the past 20 or so years has been predominantly in the criminal court in Scotland, so a great deal of advocacy work and a great deal of appellate work as well as first instance. So between the three of us, we like to think that with our very competent officials and recourse to government legal advisors, we do our best and do a good job in advising the government.
Thank you very much. Well, I think we can move in a little more detail to international law. Lord Keane.
Good morning. Clearly, and putting aside your duties to the courts, as law officers, you have an obligation to uphold the rule of law, and that is fundamental to the task you perform. And that must, do you agree, extend to upholding the rule of law in the sphere of international law, and ensuring that the executive adhere to their obligations in international law?
Well, a short answer to that question is yes. Our duties extend to international law. I would say in brief that I think domestic law and international law are quite different beasts, and they are created in different ways and ruled upon and adjudicated in different ways. But I think our duty to international law is clear. The government is committed to that. It's advanced that argument in litigation relatively recently. And there's no doubt in my mind that as a country which believes very strongly in the international rules-based order, and a country which prides itself on its ability to treaty and to contract with states around the world, that we take our obligations in the international law sense very, very strongly.
Well, you mentioned that the origins of domestic law and international law are different, and that clearly is the case. But do you agree that you have an obligation to uphold the rule of law in the sphere of international law just as much as in the sphere of domestic law?
I think, Lord Keane, you're tempting me into defining the rule of law in a way that much more advanced lawyers than I am have not been keen to do. I'm not trying to be clever about my choice of language at all. I am saying merely that my duties to ensure that the government remains on a lawful footing, both in legislation and in litigation, are both to make sure that they comply with the domestic legal framework and also with the international legal framework. I think those duties, the way in which the law is managed is slightly different, but I don't think one is in any way more important than the other. Does that help you?
Well, let me quote Lord Bingham. The rule of law requires compliance by the state with its obligations in international law. Do you agree with the late Lord Bingham?
I agree with the late Lord Bingham.
Very well.
I think that many people have tried, many great lawyers have tried to define the rule of law. Lord Bingham chose to include international law in his definition, others don't. I don't think that is the key issue here. I think what is the important issue here is that I take my obligations to encourage the government to act in a lawful manner, or to make sure that the government is acting in a lawful manner, very seriously, both on the domestic front and on the international front.
But the Ministerial Code makes clear, as it was explained to the High Court in 2015, that ministers must adhere to the rule of law both in domestic law and international law. You accept that?
Yes, the current Ministerial Code doesn't have exactly that wording. I don't read anything very seriously into that either. The Ministerial Code is merely a codification of the duties that we're under. As I have said, I take my duties in the international law sphere very seriously indeed.
With respect to the Ministerial Code, it was amended to take out the reference to international law, but the government then assured the court that nevertheless the reference to the rule of law included the rule of law in the sphere of international law.
Yes, it did, and I know that the government in litigation has said very clearly that we consider that international law to be what we want to uphold. It is absolutely, we are a country that I think, particularly at a time of enormous unrest around the world, feels our international obligations very seriously indeed. And we want to make sure that we present ourselves, and we do in fact act in a way where it is clear that we contract properly, we sign up to treaty when we want to, and we have a standing on the international stage which is very important to us.
Lord Anderson.
Well, thank you for being so clear. What you said to me at least was welcome, but I wonder if I could just try and pin that down a bit further by addressing to all three of you a question. I read a piece in The Guardian, I think about the time the Internal Market Bill was being prepared, September 2020, which quotes from a 3-page letter sent from the Attorney General's office to a senior Whitehall official at the Europe Legal Group. Appreciate, of course, none of the three of you law officers at the time. You don't need to have seen the letter because it summarises in 2 paragraphs what was then a distinction in views between different law officers. And I'd just like all three of you really to say which side you come down so we can see whether harmony has been restored. I'll quote the paragraphs. In the opinion of the Advocate General for Scotland, that of course was Lord Keane, the terms of the Ministerial Code expressly reflect a constitutional convention that ministers shall act in accordance with the rule of law, which in his view includes international law. In his opinion, that includes the obligation under international law to act in good faith with respect to the UK's treaty obligations. In contrast, the Attorney General and Solicitor General are confident that there is a strong legal basis supported by authorities which separate the rule of law into its domestic and international spheres. In their view, the reference to law in the Ministerial Code can only be a reference to UK law and UK constitutional principles. So my question to all three of you, do you agree with Lord Keane or do you agree with Michael Ellis and Suella Braverman?
I'm so sorry, Lord Anderson. I haven't read the letter or the article to which you refer, but I will make sure I do. I suspect what you're really asking is the Ministerial Code sufficiently inclusive now? Should it include international law as well in terms?
Well, certainly in a world where the interpretation of the code might depend on who occupies the position of law officer in any given government, it might be argued that there is a strong case for making things a little clearer, as they used to be. But my initial question was a much more factual one.
Yes.
I think you've made your position pretty clear, if I may say so, Attorney.
I think I have.
You were on the first of those paragraphs, and I wanted to see whether your colleagues...
I would, however, push back slightly. The Ministerial Code is not law. It's a codification of the rules and duties, the Nolan Principles of Public Life, for example, to which ministers are held and should be held. It's a matter for the Prime Minister to write it, and I don't think we should interpret it I don't think we should view it as statute. But I take your point, and I'm very happy to pass over to the solicitor. I hope I've made my position sufficiently
yes.
clear.
May I address it this way? I mean, the attorney is right, and I think this committee's excellent report, if I may say so, confirms that the code is not the source of law, nor indeed the source of the duty on ministers. That is absolutely right, and I completely endorse what the attorney says in that regard. More generally, I will come back to this specific point. More generally, I agree with the attorney that domestic and international law are different beasts. I think, Lord Keane, you made that point very clearly in the report itself, that it's more fluid and complex than the operation of domestic law. Those are your words, Lord Keane. I agree entirely with them. That is absolutely right. And I also agree that parliamentary sovereignty is different from international law. And those are my views.
Does that put you on Lord Keane's side or on Suella Braverman's side?
It puts me on Michael Tomlinson's side.
You're taking a middle position between those two statements.
No, I'm not. I think I'm just acknowledging that there is an argument in relation to parliamentary sovereignty that is perfectly valid and perfectly properly held. Perhaps if you describe that as a middle view, well, so be it.
Lord Anderson, I think I'm with the Solicitor General. The matter of parliamentary sovereignty is such that Parliament has, as it were, universal powers. And if those conflict with any obligations arising elsewhere, then on our view of parliamentary sovereignty, that must take priority. Where I see the role of the law officers is to guide, seek to influence on a case-by-case basis as and when these matters come up, bearing in mind what the matters to which the Solicitor General referred in relation to Lord Keane's submissions to the committee, ultimately forming part of the report, that the rule of law itself is a matter which, as the attorney said, I think, has been part of a conversation since the days of Aristotle. It was doubtless not formulated by Aristotle first. It doubtless reflected arguments in the Stoa at the time. It is continued. It defies attempts to rationalise it into a series of propositions. Lord Bingham, by expressing the matter in 8 bullet points, as it were, in his book, has done a great service for lawyers in relation to clarifying where the points of tension may arise. But nonetheless, when we talk of the rule of law, in my view, we speak of a conversation rather than of a settled view which is not susceptible to further change.
One of my favourite definitions is from the Harvard philosopher Judith Shklar, who once described the rule of law as just another of those self-congratulatory rhetorical pieces that grace the public utterances of Anglo-American politicians.
I think, Lord Anderson...
But it's now enshrined in statute. It's in our 2005 Constitutional Reform Act. It therefore needs to be given a meaning. And what I'm hearing from you is that depending on who occupies the role of law officer at any given time, at least 3 interpretations are possible of the phrase rule of law in the Ministerial Code. And while, of course, I accept the Ministerial Code...
Can I come back for a moment? I suspect, and I have the utmost respect for this committee, as do we all, I suspect if we were to go round this committee, we would all come up with a slightly different definition for the rule of law. It would all include, we would all include some core facts, I'm sure. I think the independence of the judiciary would be up there. I think access to the law would be considered very important. I think equality of arms before the law would be a key one. I don't want to speak for you all, but I suspect that would be the case. What I would say in practical terms is that you have heard three slightly different definitions from us today, but in practical terms, and we have been challenged, I'm not going to obviously give away the confidences of our clients by saying on what specific issues we have been challenged, but we have dealt with some challenging issues in the 8 months. Keith has been in post longer, but the 8 months Michael and I have been in post, and we have managed to come up with an agreed conclusion in those matters. So I really would not read too much into our definitions of what is a very important concept, but one that has proved very hard to define.
In light of this
Forgive me, if I could add to that, in this committee's own report, I think each and every witness that appeared before you attempted or gave a little stab at their own definition of the rule of law. And I quite like Lord Denning's formula. However grand you are, it doesn't matter, the law is grander still. But each gave their own answer, and the attorney's absolutely right. There will be cause there, there will be a core answer there. But each of us may have a slightly different gloss on it. And it's there within your report, with the evidence itself.
Well, there are, of course, some well-established international definitions, aren't there, of the rule of law? I'm thinking of the Council of Europe's Venice Commission definition of 2016, and I make myself very unpopular here, the definition in the EU's conditionality regulation, which has been the subject of a judgment by a 25-judge Court of Justice upholding its provisions. Don't you think, since it seems possible for views to fluctuate depending on who's in favour as a law officer, there would be some value in just trying to pin it down a little further, because otherwise Judith Shah is right, isn't she? And this becomes a convenient, high-sounding phrase, which on inspection, in the difficult cases, doesn't really mean anything at all.
The challenge is, how do you build on perfection? That is the answer in Lord Bingham's 8 principles.
As Professor Finnis said, and I paraphrase, broadly speaking, the rule of law is apt to describe a legal system that is working overall pretty well. The other phrase that I think Lord Bingham quotes in the preface to his book is another American academic whose name I forget, but it says that it can be resolved down to hooray for our team. Now, the point that I seek to make, and I hope not facetiously, is this, that attempts to pin the matter down risk running into problems where succeeding law officers in a succeeding government do not share the same views.
Yes.
Well, can I bring Lord Fawkes?
Yes.
Good morning, Attorney General, and welcome to you and your colleagues. It's the first non-lawyer to come in from the committee. I'm coming in with a bit of trepidation, but I was very impressed by your introductory remarks where you said the duty to accept international law is clear, that this government prides itself on accepting obligations. Now, I presume that includes the obligations under the European Convention on Human Rights.
Yes, it does.
Good. So why in the Illegal Immigration Bill, Clause 54(2), you've included a provision that the Minister of Crown may make arrangements for removal not to apply in relation to a person, which goes completely against a decision of a court to which we adhere?
I won't get too drawn into specific discussions on the illegal migration bill. We don't, by convention, talk in public about whether or not we've advised or precisely what we've advised the government in any specific issue. And the illegal migration bill is clearly a live issue. It's before your Lordship's house today. Lord Keane will be on his feet later today representing the government in the House of Lords. And as you know, the matter is also, we're anticipating a ruling from the Court of Appeal tomorrow morning on the substance of the Rwanda policy. So I'm very sorry, but I'm going to find it very difficult to answer your question with the specifics that I think you'd like me to. Can I say broadly, that my career as a government lawyer has led me to think very deeply about the duties of the government as both a legislator and a litigant. I am under no doubt that it is not right that the government should take an argument which is not proper to a court, but that it is perfectly proper for the government, when it has a respectable legal argument and when it feels the law should be tested, or indeed in an area where the law is not completely clear, to take that argument and to proceed with it.
You can see why I'm just a little sceptical about all the wonderful words you said at the start about adherence to the rule of law and we are in the forefront of it and so on, when a court, which we were principally involved in setting up, Winston Churchill was involved with the Council of Europe, we set up the European Court, and now you're part of a government which is supporting this clause, which makes it clear that a minister, just a minister, not the Parliament, just a minister, could overturn a decision of the European Court of Human Rights.
I'm so sorry, and Chair, will you forgive me if I don't get into the specifics?
I understand
what I would say in answer, if I can try and keep this as broad as possible, I am sorry, I really am, is that I take the convention very seriously. I have practiced for almost all of my legal career, apart from at the very beginning, in the human rights field. If I have a specialisation, it's Article 2 and Article 3 with a few bits on prisoners thrown in. And I read the judgments of the Strasbourg Court carefully, obviously while upholding the independence of the judiciary. I agree with some of them. I don't necessarily agree with all of them. I have advanced cases on behalf of the British government which we've lost from time to time. However, what I would say is that we have the best track record of any state party before that court. We have the utmost respect for that court. This government supports being part of that court and the ECHR, and the Prime Minister has said that himself from the dispatch box. I've heard him do it. I had a really good trip to the Strasbourg Court during February this year, and we were able to talk through some of these issues very frankly, both in public and in private.
Can I just say, finally, I completely understand the inhibition on you for commenting on this. And can I also say that as a member of the Parliamentary Assembly of the Council of Europe, we visited the court just after you and got the same, not impression, the same facts, that we are in fact one of the countries that comes out best in terms of referrals to that court. And that's why I'm even more disappointed that we're not dealing with it in this case.
Can I just pick up a phrase you used in answer to Lord Fawkes? You used the words respectable legal argument, and I'd like to explore that a little further with colleagues, because the question that is passing through my mind is whether those words are sufficiently meaningful to maintain public confidence. Now, it mentions the of sovereignty of Parliament. Of course, Parliament can override international law if it wishes. But then the question is there a respectable legal argument that it would enable you to advise ministers that they should do that? Can you just elaborate a little more on the thought process that you employ, Attorney, in deciding whether or not to say yes, and whether the phrase respectable legal argument is one which you apply and what it means to you?
Yes, I start from a position of my professional obligations, so my obligations as a lawyer and as a barrister to the court, which is where your first question started, really. I then, and I think I must be honest about this, come with a great deal of government legal service experience to that particular test. It's a test that was set out in AG's guidance. We still have Attorney General's guidance, and it's there really to assist government lawyers in the course of their work. But I also, because I was a government lawyer, and well, I am now, but I was for my whole career, come at this from a position of understanding how government lawyers are supported in their work. I know, and I really do believe this, that the government has extra duties as a litigant before the courts. We have the duty of candour, we know that, that's come from case law. But we also have a duty to, as all lawyers do, but I think probably a bit more, to advance proper arguments. What that means can really vary from case to case. If, as I said earlier, if a matter is a legal position is not clear and needs clarification before the court, that may well be a good reason for the government, who is in a strong position as litigator. It sees a wide range of litigation and is well resourced. It may well be proper for the government to try to take a case forward to clarify that argument. But I'm in absolutely no doubt that the argument is one that any lawyer must consider to be a proper one to put before a court. That is, it cannot be an argument which would be improper to advance.
Yes, I think our concern was increased by some remarks made by your predecessor, who suggested that government lawyers are being too cautious in their approach, and they should adopt a solution-based approach, be inventive and so on. Now, that strikes us as really stretching the respectable argument rather far.
I feel very strongly, as a former government legal lawyer, that I am really well supported by the government legal service. In my experience, the government legal service is full of lawyers who have a firm understanding of our Constitution, base in the common law and the way that it evolves, which is, as you know, through interaction with the courts, and yes, a creative approach, but that in no way negates their obligations. So their professional obligations and their additional obligations as a government lawyer are very important to them. But there's nothing improper in a government lawyer suggesting mitigations or other ways of achieving a policy aim which the government wishes to achieve, which are not in themselves improper or unlawful. Does that help?
Well, I think she suggested that you should adopt a private sector approach to this, and taking yourself back to private practice, you might imagine cases where you give your initial advice, which the client doesn't like, and says, I'm sorry, I want to press this argument. And then you're faced with the position as to whether, as a responsible lawyer, you can say, yes, you should go ahead with this, and you have to begin to apply a test. Is that not where the respectable argument really comes into play? Mm-hmm. You're facing a minister who says, I want to do something. Your initial instinct is to say, no, that is not acceptable because it's against the convention or whatever else it may be. And then you're faced with the question, how you resolve the difference between you.
Well, that goes to the very heart of what we do as law officers. I would hope, and in an ideal world, we'd be consulted early in the formulation of a policy or a piece of legislation, for example. And if we are, we're able to set out very clearly what the legal position is, what would be a proper basis for an argument, and what, frankly, wouldn't. And then we're able to give our legal advice in that setting, if you like. It's not for nothing that predecessors, and there are some distinguished former law officers on this committee, it's not for nothing that my predecessors have alluded to the fact that you are often unpopular as a law officer. You do have to be able to say no when necessary.
Yeah. Lord Keane.
Well, I think, in a sense, the attorneys covered the points that I was going to raise in that context with regard to respectable legal argument. It is a final test, surely. It's not the first test you apply when presented with a piece of proposed legislation.
No, and it's a test really as which can differ. I accept that in different contexts. There may be issues which should and we properly bring before a court in an area where there is real legal uncertainty, for example. But in other areas the law may be clear, and so the test is a much higher one. It does vary from issue to issue, as I know you know very well.
May I come in?
Yes, do, Keith.
Lord Anderson, I'm going to ask Baroness Finn before you, if you wouldn't mind.
Go ahead.
Okay, thank you. I just wanted to pick up on the point about the legal advice being cautious or solution-based. Part of the criticism when I've been in government is that the legal advice was often very full of why one couldn't go ahead with a policy, and that there would be you'd have the legal problem of X or Y or Z. I think there was a desire, if this sheds some clarity, and I'd be interested in your view, that the legal advice should maybe seek to find a way around some of the legal obstacles and be more constructive than just trying to prevent something happening. Because there was very much a feeling that the legal advice, when I first started, was very busy telling you why policies couldn't go ahead, rather than, for example, if one worked for a newspaper and you're told that you can't actually print something, the lawyers would then seek to work out a way you can say it in a legally possible way. Would that be your view?
Well, I think that's a very interesting way of describing it. I do think that government lawyers, who are also civil servants, so they have their obligations as lawyers, and then they have separate but complementary obligations as civil servants, give really good and really useful legal advice to government, and I'm very proud of the work that they do. In my experience, which has been in government since 1997, I think that government lawyers are very keen to find solutions where possible. That does not mean working to within, it doesn't mean working backwards, perhaps if I can put it that way, from, well, you can't do this, but you can perhaps do the rung immediately below it. I prefer to view it as a collaborative process within government. Government lawyers are often embedded with their policy clients. They understand them and the policies that drive the government and those policy clients very well, in my experience. And they're able to get involved right at the inception of a policy and say, this is what makes the job, in my view, so exciting and so unique. You're able to get involved right at the beginning and say, well, you can't do it that way, but you could possibly start from here and do it this way, and then assist the policy client throughout the evolution, if you like, of the policy to a place of legal propriety. That's slightly different from being presented with an ask for your legal opinion, and a specific ask, is this a respectable legal argument or not? I think the two they may come together, but they're usually slightly different starting points.
Thank you.
Attorney, I was going
yes,
to,
go on.
if I may, Lord Chairman, I was going to come in and say that, of course, the framing of prospects in the terms of respectability tends to be accompanied also by an expression of prospects expressed as a series of percentages. Now, lawyers all in practice are faced with the difficulties posed by clients who are unfamiliar with legal complications and wish to have their prospects resolved abstracted away into terms with which they find it easier to grapple, such as percentages. It is always a matter of abstraction. It is always a matter of expressing things which are not susceptible, in many cases, to such precision in terms which have the appearance of precision, and that can be misleading. But what I would say is that the combination of the bar of respectability, the percentage breakdown with which we're presented by officials and occasionally by external counsel, together with what the attorney speaks about the opportunities to mould policy from its inception into terms which would be acceptable to the court ultimately, all assist in the process of making sure that the government presents its case on the strongest possible legal basis. And just a further point which I would make is, of course, that in relation to the point which you take up, Lord Chairman, in relation to the views expressed by a former Attorney General, I think we have to bear in mind, of course, that law advances by testing propositions in court. And occasionally, we find, as we look back over legal history, we find propositions which are now widely accepted were controversial at their commencement. That is how law works. We cannot stand still, as it were, in relation to a changing world and changing circumstances.
May I add very, very briefly to the point that Baroness Finn quite rightly said about being solutions-focused. And actually, it's the early conversation that the attorney was talking about that's critical to that, making sure that it's not just a, no, you can't do that, but you're having a genuine, grown-up, proper discussion about how to achieve the aims and objectives, but to do it in a lawful and sensible and proportionate way.
So it could work through that. First of all, you say no, then you're asked to find a solution, you propose a solution, and then the question is that one which you can actually respectably proceed with?
I'm sure there are a series of steps that can be made, and I think the example you give is a very good one. But the key, as far as I'm concerned, is to ensure that approach is made early, so that you're not, as it were, at the door of the court when these decisions are having to be made.
Lord Anderson.
I should declare an interest as a barrister who's done very many cases for the government legal service in the past. Might I echo, Attorney, what you've said about them, the high praise you've given them. I've found them always an admirably professional body of people. And speaking personally, I have no difficulty with the respectable legal argument test, or indeed with your very helpful bands of likelihood, 30 to 50, 50 to 70, and so on. They seem to me to reflect very much what it is possible for a lawyer to say. And indeed, it's interesting to see that you notice people now advising private clients and adopting the same
in a similar
bands.
way. I've noticed that.
Because there is sense in them. But my question is, after that very flattering bit at the start, whether you think there is any category of cases that should be subject to a more stringent test. I'm thinking, for example, of decisions to authorise armed conflict, perhaps decisions where there is a risk that somebody may be exposed to criminal liability. It might be thought to be a bit insouciant to embark on courses of that kind, simply on the basis that the legal argument is respectable. I don't think I saw in the guidance any category of cases to which different words might apply, but it may be that in practice they do.
I think any decision to go to war or to engage in armed conflict would have to be taken very seriously by government, and I'm sure is taken very seriously always by any government in this country. I'm not sure that changing the test, this is one part of your excellent report that I wasn't sure that I agreed with. I'm not sure that codifying the type of cases would really help with that decision. I'm absolutely certain that attorneys who have to assist a government when deciding whether to engage in armed conflict would take their responsibilities particularly seriously. I have no doubt about that. But I still think the test, in which I accept there is inherent flexibility, is sufficient, because the attorney can balance all of the other considerations which might need to be borne in mind, the need for humanitarian intervention, for example, the speed of response. And I think the attorney would, within the confines of the current guidance, be able to make that decision properly.
There was a particular point that came up with one of our former members who was Secretary of State of Defence during the Kosovo War, and he was faced with a problem that his military advisors were saying, we need to bomb a particular building in a city, and he was very worried as to whether or not that would be something that he could do compatibly with the rule of law, and that's where he turned for advice, which he, in fact, was given that it was actually so, but he was heavily dependent on that. He made it very clear in our meeting when discussed how crucial to his decision the legal advice was before he could authorise the activity to take place.
I am absolutely certain that both I and my predecessors would take our responsibilities in that regard very seriously indeed.
Yes.
Lord Chairman, I do beg your pardon.
Sorry?
I do beg your pardon, Lord Chairman. I thought that another member of the committee was going to come in.
Well, there is, yes. Lord Falconer, I think, would like to come in. Lord Falconer.
Yes, could I apologise first of all to the attorney, the solicitor and the advocate for being late. Could I also say how very much I agree with what the attorney has been saying about the quality of the government legal service when I was a law officer. They were absolutely excellent and they were very, very sensible. I think this debate that we're having about what's a respectable legal argument is almost at the core of a good or a bad law officer in a way. It's what's respectable. And I'm just picking up what Lord Hope has said. The Kosovo experience involved saying whether it was okay to target the suppliers of energy in Belgrade, which have a big effect on the supply, for example, of electricity to hospitals. You can't be saying, can you, that as long as it was arguable, even though you think it's wrong legally, that such targeting would have been allowed legally?
Well, Lord Faulkner, I'm very grateful for what you've just said, not least because I was one of the junior lawyers who instructed you once, or who assisted you,
and you were
when you were a law officer. I think the point you make, I accept the point you make. These are very, very difficult decisions. However, what I'd say is that it is the duty of the law officer, and if I may say so, I saw you do this, to set out what the legal parameters are. You set out to your clients, well, we obviously armed conflict is not normally lawful unless there is a reason why, so customary international law or the UN, and you set out the parameters of what is permissible and why that is the case. You set out, if you like, the level of clarity you feel about the advice that you've given, but you make it quite clear how strong that advice is and what you feel about the strength, if you like, of those arguments. And then you assist your client, who is well known and trusted by you, you hope, as the Defence Secretary and Prime Minister and others, possibly in NSC or other cabinet committees, to make these very difficult decisions. Some of their decision making will be lawful. You have to explain what the law is and how strong the case is. But some of those decisions will be humanitarian, frankly.
But in relation to the example given, if the attorney, it was then John Morris, who was a brilliant attorney, if he said it's not lawful, in my view, then isn't the position the government couldn't do it? Sorry, did I repeat the question? Sorry.
Yes, I'm sorry.
The attorney at the time was John Morris.
Yes.
If he said no, and from time to time he did say no to particular targets, then the government could not do it.
That's the law, Lord Faulkner, and you know that very well. And so do we. And even though I'd love to get into specifics of advice that both you and we have given, you know that we can't. But yes, of course, our job is to say no when it's necessary.
But I mean, I'm saying more than that. I'm saying if the attorney said no, which he did in relation to some of the targets, the government would be obliged not to do it. The way you're putting it is to say, oh, well, if he says you can't do this legally, still they might do it.
No, that's not the way I'm putting it. I'm agreeing with you.
I misunderstood it. And then just this wider thing about respectability. I completely see the utility of a respectable legal argument that might be quite a bad one, but is respectable, might be one that it's quite legitimate to pursue, for example, when there's a sort of damages dispute going on between the government and a private contractor. But there are certain things in the public eye, or which give a sense of the reputation of the government. For example, I mean, don't comment on this, but where, for example, one is dealing with whether or not one should withhold documents from a public inquiry, that is something where simply having a respectable legal argument which might be wrong wouldn't be appropriate. Do you agree with that? Don't comment.
Well, I can't comment on that. You know that.
You obviously can't comment on the individual case, but what you're saying, with which I strongly agree with, is what constitutes respectability depends on the context. And I would be keen for you to give some indication to the committee of where's the difference between, on the one hand, using military force, and on the other, what might be properly viewed as a commercial dispute, which would be something really different.
Okay, yes, I do think that the weight which should be attached to the test, if you like, can be different in different circumstances. And while I think we would enjoy very much discussing specifics, we all accept that we can't. So I think armed conflict is, yes, on absolutely one side of that divide, and we've discussed the reasons why with Lord Anderson. I think also taking people's liberty away, which was the second point that Lord Anderson made, is very serious too. I think on the other side, I would probably stick, if I may, to cases where the law needs clarification, where there is genuine uncertainty on a legal issue and it is proper for a litigant, in this case the government, a well-resourced and well-supported litigant, to take a matter to court where the argument may look on the surface to be a less strong one, but is nevertheless perfectly properly advanced.
I'd like to move on. Time is a bit short, as you know. I'm going to ask Lord Thomas to introduce a question about Section 19 of the Human Rights Act, which you're all very familiar, I'm sure. Lord Thomas.
Yes. What role do you play in advising whether a bill should be subject to a statement under Section 19(1)A or 19(1)B of the Human Rights Act? And who advises on the content of the ECHR memoranda which accompany bills?
The short answer to that is normally departmental lawyers advise on the content of the statement, and normally the Section 19 statement is signed by the minister promoting the bill. When a matter is controversial or we think that there may be contravention of the convention, then we in the Attorney General's office are very likely to be consulted. We then work with the departmental lawyers, but ultimately the preparation of that memorandum is a matter for them and the signature on the bill is a matter for the minister.
There is obviously a clear distinction between 19(1)A and 19(1)B, because 19(1)B it is contemplated that you are going to breach the Human Rights Act in some way. So is there any machinery whereby the 19(1)B decisions come to the law officers?
With respect, I don't accept that characterisation of Section 19(1)B. If we use a Section 19(1)B statement, it doesn't mean that we believe the bill to be incompatible, and it may well mean that we would mount a very robust defence if challenged legally on the issue. We, the government, as a former civil servant, I use that for all of my periods in government, but previous governments have on one occasion, well, more than one occasion, but one occasion on the basis of considerable advice, used a Section 19(1)B statement. Tessa Jowell used it for the Communications Act. What had happened in that case is there had been another state had lost a case before the European Court, which went against what the government here wished to do. I'm sure that advice was obtained from government lawyers at that time, and it was decided nevertheless to proceed with the bill, the Communications Act, on the basis of a Section 19(1)B statement. The bill went through, the government was challenged in court and ultimately won that challenge. So I do not accept the characterisation that a Section 19(1)B means that we are contravening the ECHR or other law. It just means that we know that a challenge is likely, but that we will defend ourselves.
Well, I'm not suggesting that. But surely you wouldn't leave it to departmental lawyers to determine a 19(1)B issue, would you?
Well, I'm sure that in the case of a Section 19(1)B statement, the departmental lawyers would be in very close contact with me and my office.
Yes, it would go to the top.
I would expect, if there was a real concern about compatibility, for it to come to me. However, most Section 19 statements are dealt with by departmental lawyers in the normal way, but that's because they're Section 19(1)A statements.
I did ask who advises on the content of the memoranda, so...
Again, in the vast majority of cases for bills, that's the departmental lawyer. If the matter is controversial or there is a real concern about whether or not to use the Section 19(1)B statement, then we in the AGO, both me, the other law officers and our officials help.
May I go?
Yes, do.
May I come on this? Because the Attorney very kindly delegates to me the privilege of sitting on the Parliamentary Business and Legislation Committee that obviously deals with legislation coming through. And before there's an ECHR statement, there is within the body of papers that comes before that committee a legal issues memorandum, and that very often it invariably involves a discussion between the department and the Attorney General's office. And so even before we get to the point of a statement, there is engagement with the bill team, there is engagement with the department and with the lawyers in the Attorney General's office as well.
Well, that's interesting. You're saying that the issue would pass your desk.
No, I'm not. It wouldn't necessarily pass my desk. It passes my desk at the moment that I enter, or hopefully in advance of me entering the committee. But no, I would expect that to be dealt with at an official level, as it would in the ordinary course.
Lord Strathclyde.
Yes, you've kind of preempted a question that we were going to come to about the Parliamentary Business and Legislation Committee, which I regard as being an important part of the framework before a bill comes before either house or both houses. So what steps do you take to ensure that rule of law implications are considered before the bill is introduced? Now, obviously there is the Parliamentary Business and Legislation Committee, but what happens before that in the discussions with the bill teams, with individual ministers? And ultimately, do you feel that your advice, which I'm sure the answer is yes, is taken most seriously, and you are not overruled, that you virtually have a veto on these sorts of issues?
The short answer to your latter point, Molly, is absolutely yes. It very much not just feels like, but it is de facto a veto. It's a very serious committee chaired by the Lord President of the Council, who, as you know, takes her role incredibly seriously. And absolutely the law officers. I sit there as the Attorney's deputy. I think that's traditional and has been the case for as long as I can remember. And the Advocate General sits there in his own right. And it is absolutely right that the law officers are properly deferred to and consulted. You asked in the beginning part of your question about events before getting to committee and in the run-up to that. Yes. Especially where legislation is difficult. There are often, for example, questions of consent for retrospection. That's quite often where our role comes in. Is it right and appropriate that the presumption against retrospection in any bill should be overturned or overruled in this particular circumstance? And these are issues that we grapple with well before we enter into that particular committee room.
Thank you very much. That's very helpful.
And before we get to the door of the committee room itself, I would say that the more chance that there is that a bill's provisions will be controversial, the earlier bill teams will have grappled with it, involved the law officers, and if necessary, our advice will be the apex of a pyramid which from its base begins with officials but will include external counsel. And to the solicitor's point about the weight with which the committee ascribes to the law officer's view, on a number of occasions we have had to make it clear to departments that their bills are not in an acceptable form, and the committee has acted on that, and bills have been pushed back into later on in the session, so that there is no doubt in my mind that the scrutiny which that committee provides over legislation is not only active but meaningful.
Very reassuring.
Lord Anderson.
Thank you, Lord Chairman. I was just trying in my own mind to map the 19(1)B jurisdiction over onto your own legal risk chart that features in your Attorney General's guidance. And I entirely accept the point you make on the Communications Act 2003, it was quite marginal, and in the end it turned out that you were right, and it was compatible. And I assume that might have been a medium-high risk of challenge, perhaps in the 50-70 range, if you were applying the current guidance. But when we look at a 19.1b statement, I assume that it might have been a case in the next category where there's a 70% chance of successful challenge, but you have at least a respectable legal argument. And my question is it feasible that it might also, a 19.1b statement, be compatible with the very last category, in which it is said that no respectable legal argument exists to justify the decision or policy, or in this case, the clause of the bill? So is it possible that any of those three categories might be the explanation of a 19.1b statement, or is the last category definitively ruled out in all circumstances?
I would not want a bill to proceed if there were no respectable legal argument that we could advance before a court that it was lawful.
And if it did proceed, would that be a resigning matter?
That matter has not arisen. Well, Lord Keane, I think, could perhaps tell you more about that than I could.
Thank you very much.
But I don't feel in any way, I feel quite confident in my ability to give clear legal advice to this government. I feel quite confident in a way that legal advice is accepted, and I really don't think the matter arises. The government does not want to put forward legislation which is improper.
And I move on to another different topic. Lord Thomas, the question of advice being disclosed outside government.
Yes. We said in our own report that in exceptional cases, perhaps the advice should be disclosed. What is your view about that? And if you just give me a moment, are there any circumstances in which you would authorise your advice being disclosed outside government? We all remember the conflict over the advice on the Iraq War of Lord Goldsmith.
We do. I am very reluctant to disclose legal advice generally, actually, but particularly legal advice that we give to government. I think it's very important that the government benefits from free and frank advice, and I am quite sure that if we were to share that legal advice, in most cases, that would have a chilling effect on our ability to give the clarity of advice that we would wish to do, and it would affect the government's ability to litigate, which is not something I would want to do in the generality of cases. However, there have been some very, very exceptional cases, once because, partly stemming from a leak, and once because of a humble address where legal advice has been disclosed, and I think one other case where it was decided that legal advice was needed. If a matter is genuinely constitutionally very important, then I can see an argument for the government's legal advice, a legal summary being prepared. That is slightly different from advice that the law officers may have given earlier, but of course ought to reflect that advice, though be a summary of it. I can see that could be appropriate and is appropriate in cases. Well, we had the Windsor framework to consider where the government did provide an explanation of the legal position, which I think was helpful. I suppose the argument traditionally is in cases of armed conflict where it might be necessary to provide legal advice. I'd rather not give a definitive answer on that now, if I may, except to say that I am sure that any future attorney or me, if in post, would consider whether that would be helpful on a case-by-case basis.
You will remember that the officer in command, who is a member of this House, at the time of the Iraq War, refused to move unless he had definitive advice from the Attorney General that armed conflict was lawful in the circumstances. And in a situation like that, gave rise to a great deal of controversy. You would agree that the advice should be disclosed?
Well, in that case, the advice was disclosed, so there's no point in relitigating this now or here. I can see that there are exceptional circumstances, very exceptional circumstances where it might be appropriate. But I do feel very strongly that normally government legal advice should be protected in the same way that any other relationship between lawyer and client is respected. I think it's very important that both we as law officers and also the government legal services is able to provide really clear and frank advice, and I cannot emphasise that enough. But I accept that there can be very exceptional situations where that isn't the case.
Would the need for public confidence play a part in that?
It might do, and the very rare occasions have included public inquiries, for example, after the event, where it has been deemed wise to release government legal advice, sometimes a long time after the event, when you want to give the fullest possible picture to an inquiry.
Your colleagues have the like view?
My view is that the attorney's advice should be almost never disclosed. I think the attorney is absolutely right. I agree with her entirely with what she says, in particular with her comment on the chilling effect. And we can all imagine scenarios where we're advising clients. As lawyers, it would be completely inappropriate for that advice to be disclosed, and it's no different in this scenario. There is a real chilling effect if there is a prospect of advice being disclosed, and I strongly agree with what the attorney has said.
Well, I'm moving on to, sorry, Lord Stewart, another topic, but very shortly.
Very shortly, I would agree with my colleagues, but agree with what you said, Lord Chairman, about the matter of public confidence. I have not, and hopefully never will have to advise in the awful circumstances of committing the armed forces of the Crown to conflict. But I fully appreciate that in such circumstances where such an awful step is contemplated, that the disclosure of the legal basis upon which the government acts ought perhaps to be made public in order that the public be reassured.
Yes. Different topic, devolution. Now, I think both the Attorney and the Advocate General, possibly Solicitor too, have a part to play in decisions about devolution. But Lord Foulkes, would you like to open on this?
Yes, this is another kind of conflict in some ways, I suppose. We want to explore what role the UK government, particularly the law officers, and in very particular the Advocate General, Keith, that you have in relation to particular areas. For example, if there is expenditure by a devolved government, in this case, let's take Scotland as the example, if the expenditure is clearly ultra vires, if I've got my Latin legal term right, and out with the powers devolved to that, what powers do you have? Now, we have Lord Malcolm Offord, who is very strong and very powerful in the words he says, but the action doesn't necessarily follow. If I can just take one specific example, where the Scottish Government is spending a lot of money, a significant amount of money, on a Minister for Independence, when there's clearly not going to be a referendum, where constitutional matters are not devolved to the Scottish Parliament and Scottish Government, and where clearly it is a political campaign. And yet also money, UK taxpayers' money, is being spent on 20 civil servants, UK civil servants, to support that minister. Surely you must have some powers as a law officer to intervene in that and to take some action against expenditure which is clearly improper.
Yeah. The role is to patrol the margins of the devolution settlement and to do our best to ensure that the devolved administrations act within the terms of their competence. The example that you give is a good one. I think it would be wrong to characterise Lord Offord's position as one of impotence in the circumstances. He has explored the matter politically. That and other matters relating to the vagaries of Scottish Government expenditure come across my desk on the basis of closely involved work with officials, not only legal officials, but also officials superintending my office. And we look very carefully at it. It's also open to me to raise of my own volition such matters, as I have done. The position, therefore, is that the manner in which the Scottish Government or other devolved administrations choose to spend the money that they get from central government is first and foremost a matter for them. But where they exceed their responsibilities, we can step in. And I think to give a recent example of another matter which has interested your Lordship, in the activities of a devolved administration presenting civil servants as, in a sense, ambassadors for that devolved administration, or acting in the capacity of embassies. What I've done is looked at the facts and circumstances applying, got a clear indication of what those are, and sought to act accordingly. So that, for example, in relation to the embassy's point, the FCDO now takes a far stronger line in seeing to it that our overseas partners are not doubtless inadvertent. Now, there is no risk that inadvertently they might be left with an inaccurate impression of the limits of a devolved administration's authority. So that, for example, I understand that a recent initiative of that sort by a devolved administration was accompanied to the European Union, was accompanied by our ambassador, that is His Majesty's Government's ambassador to the European Union, to make sure that there was no confusion between the respective roles of Westminster and the devolved administration in question.
Can I say, I think the government is to be commended on that, and you and your colleagues and the Foreign Office, or Foreign Secretary, made it absolutely clear, and I think that's clipped the wings of Angus Robertson very effectively. That's why I didn't use that as an example, because I think you have done that. But I think it's an even more glaring example, and it is causing, as you will know, and as Lord Keane and others who live in Scotland know, it is causing a great deal of concern amongst people. I have people stopping me in the streets in Edinburgh, at Tynecastle Park and other places that I go to, saying, do something about this, George, for God's sake. They are using our money improperly. You've got the powers, or I think you should have the powers to do something about it. And I mean, particularly in relation to the expenditure on civil servants. The Permanent Secretary sits in every week at the meeting that Simon Case has with all the permanent secretaries. So he's part of the civil service. So surely there must be some way that they can be told that this expenditure is improper and should be spent. I mean, there are other areas that are underfunded. Would you look at it again and see if something can be done?
I can give that undertaking, and I may say I have the same experience as Lord Fuchs, as though it's a while since I've been at Tynecastle. But nonetheless, I have the experience of being challenged as to the apparent exceeding of its powers by Holyrood in relation to that and to other matters. I can give the committee this assurance that whilst we work with the devolved administrations in good faith, and that overwhelmingly our engagement is positive with them at an official level as well as at a ministerial level. We are not blind to the possibilities that, for political reasons, they will seek to test the parameters of that devolution settlement. And we are on our guard to make sure that that doesn't happen. It may happen inadvertently, it may happen as a matter of political priority for the devolved administration in question.
Could I ask you a question about the Internal Market Act? Because as you know, there is a possibility of an exemption against the market principles which patrol the internal market and require uniformity throughout the whole of the United Kingdom. And there are cases where exemptions have been given where a devolved administration wants to differ and protect its own position. Do you play any role in that? And I'm not looking for specific cases, but do you police that as well as the devolution settlement, which is a separate issue?
It would certainly come before me. I had involvement with the Secretary of State for Scotland in relation to just such an issue quite recently, in which there was a considerable amount of disquiet in Scotland in the licensed trade and in other sectors, exporters and manufacturers of products in relation to the deposit return scheme. Now, as a result of reconsideration by Scottish ministers, that particular initiative has been pushed back in time. And we sought to, I think the Secretary of State has sought to impress upon Scottish ministers the desirability of operation across the United Kingdom internal market. I have not specifically asked to advise about the legality of that particular instance, but the committee will be aware that my department, the Office of the Advocate General, does scrutinise the activities of the Scotland, the Scottish administration, Scottish government, carefully.
Yes. Does this extend to your responsibility as attorney and solicitor? I mean, you do have powers under the Scotland Act to intervene in certain circumstances, but do you keep an eye on this as well?
Oh, yes, very much so. And I must say Keith's knowledge and experience is invaluable to our team. We discuss Scottish issues formally at least once a week at our law officers meeting. But when matters arise on a day-to-day basis, Keith keeps us very well informed. As you know, we sit in the law officers' corridor. Yes. The doors are very open, and we pop in and out and are very aware of what the others are advising on. If I may, I would just say briefly that we take our responsibilities to all parts of the UK very seriously. The union is very important to us all, as is the protection of the devolution settlements. We were called as a group in Northern Ireland to the bar there, which was a very rewarding experience, and I think hasn't happened before as a group of law officers. We make sure that we visit Wales often, and Keith obviously is in Scotland every weekend, and we've had formal visits in Scotland too. This is a very important part of our work.
Very much.
And I may say, Lord Chairman, that this is something which existed prior to the Attorney and the Solicitor General coming into their office, that the same close consideration to devolved matters was given by the Attorney and the Solicitor's predecessors.
Thank you.
Has the UK ever instituted litigation against one of the devolved administrations for acting unlawfully?
There have been a series of litigations, Lord Thomas, a number of litigations, I should say, some of which Lord Keane appeared for the UK government. Most recently, we have one case which is presently before the court in relation to Section 35 of the Scotland Act, which bears upon the Gender Recognition Act passed by Holyrood. The Lord Advocate, the Scottish Government's law officer, brought an action, or rather approached the Supreme Court seeking guidance, if I may, in relation to whether or not it was possible for the Scottish Government, independently of Westminster, to call for a referendum. Prior to that, in my involvement, or rather since my time as Advocate General commenced, we had the action relating to the compatibility of two bills which the Scottish Government had taken through Holyrood, and we took the matter to the Supreme Court in relation to the compatibility of aspects only of those bills, and were successful. And Lord Keane, as I say, as Advocate General, had acted previously in relation to the continuity bill matter.
Yes. We've got 3 questions to go. I hope we can get some view from you on each of them. I'm turning to Lord Strathclyde for the position about the international stage, and also I'd like him to deal with the advantages of the Attorney attending cabinet meetings. I wonder if you can deal with these two
at the same time.
Yes, please.
Well, I mean, on the stage, you've obviously commented before, and I mean, very, very briefly, can you give us an update on the role that you play on the international stage, particularly to protect and promote the rule of law vis-à-vis Ukraine or anywhere else? And the second question I had to ask was about your attendance at Cabinet. Are there advantages in being there? I'm sure there are, but are there any disadvantages in attending the Cabinet, which is perhaps more pertinent?
If I may, I will answer as briefly as possible, because I know Lord Hope is right to keep us to time. The government takes its responsibilities as, I hope, a leader on rule of law issues and on the international rules-based order very seriously indeed. As I said, we visited Strasbourg in February, and that was a good trip. I know that the solicitor is making a trip, he can explain, and Keith as well, to various international conferences, and it's quite right and proper that we do that. Ukraine, as an appalling example of when rules are not followed and law is not followed, and relationships between countries break down, has of course been very, very high up our agenda. It's high up my agenda personally. My daughter used to live there, and we have, partly as a result of that, had a Ukrainian visitor living with us for the last 16 months. And we have welcomed also a large number of her family and friends to our neighbours, and it's become a very big part of my home life. It's interesting that it's become a very big part of my work life as well. It was when I was previously a minister in agriculture, because obviously grain is critical to the economy of Ukraine, and it has been a big part of this job. I have a close relationship with the Prosecutor General of Ukraine. I've met many justice ministers and others involved in the Ukrainian government. I was fortunate enough to be able to visit Ukraine both before the war to see my daughter, and also earlier this year when I went to an international conference about the ways in which we can hold Russia accountable for its actions. But I was also able, and I think this is important, I'm sorry, Lord Hope, but I will be as brief as I can, to lay a wreath in Bucha, almost exactly a year since the really awful atrocities that took place there. And I think all of us can remember the pictures of that pit with 118 bodies in it. Bucha now, and a year on, was extraordinary. It was cleaned up. The beautiful white church had been freshly repainted. It had an exhibition of well-choreographed, though very disturbing, photographs of the atrocities. And the people and the priest were there to meet us as we laid a wreath to remember those who had died and been tortured. The extraordinary thing for me as a lawyer and a proponent, if you like, of the rule of law, and this is why it's more than warm words, the rule of law, was that some of the perpetrators of those atrocities have already been brought to justice. Some are in prison, and some have been used in prisoner swaps. The Ukrainian government, which has 92,000 open war crimes cases at the moment, is is prosecuting in a way which international bodies have deemed to be perfectly acceptable. It is prosecuting right now in real time war criminals. This, I think, is useful both because it ought to affect the behaviour of troops on the front line. If they know that if they behave badly, they will be held to account for their actions. And also because I think it shows that the rule of law really does matter, and that is what Ukraine is fighting for. So the Bucha trip was exceptional for those reasons, but our help and support for Ukraine goes much, much wider. I talk to the Prosecutor General very frequently. We're working on what he refers to as his web of accountability. So that's everything from ICC, which we support both financially and in other ways. We send them some very good lawyers. It's good that Karim Khan is a British lawyer, and we have a close relationship with them and want to support them. We're part of a core group which is discussing what form of international tribunal will be necessary in order to bring perpetrators to justice. We're supporting very practically on the ground with the war crimes cases, 99% of which will take place in Ukraine. We've given the Ukrainians one of our most senior international judges, Sir Howard Morrison, to train their judges. And he's doing that. He's trained over 100. I've met some of them. That work has been very well received. This is nuts and bolts stuff on how to run a war crimes tribunal. It's really good. And we're supporting with evidence collection, the full gamut of the justice system. We are supporting wherever we can. I know that many British lawyers are keen to get involved and give their time for free. Some of them have already done so. I know there will be many years of help that we can provide. So, yes, this is important to the government. Do you want to say very briefly your international travel? And then I will answer your other question. I'm so sorry.
Well, Lord Hope, having heard that, there is also the Attorneys General Overseas Territories Conference that happens regularly as well.
And there's the aspect of the desirability of contact between legal systems, between bars, between law officers, in order to understand better the priorities and the imperatives that apply, and to participate in the continuing development of law geographically and indeed as part of the historical process. I am possibly attending an International Bar Association conference in October. I was always slightly sceptical about these things when I was in private practice, when I've had to put my hand in my pocket in order to attend. But I appreciate having left the world of private practice and seen the way in which lawyers who do not enjoy the benefits of membership of a tradition as established as ours benefit from the contact with and the discussion with and the approval of the British legal systems.
Our time is running against us. There's a question about membership of the Cabinet. Baroness Satie would like to come in, and then Lord Anderson on Julie Linnon's sentences. So try.
Lovely. Sorry. Membership of the Cabinet. I attend all Cabinet meetings. I'm not formally a member. I think this is useful. It means that I know what stresses and strains my departmental colleagues are under, and I'm fully apprised of what is top of the government's agenda. It also, of course, provides opportunities around the edges of meetings for colleagues to have private words about what is concerning them. And disadvantages, I don't think there are any. I think it works very well at the moment. I try not to speak on non-legal matters, but occasionally an agricultural thought pops out.
Baroness Satie, who has a particular interest in Ukraine, I think.
Well, I was delighted to hear what you were saying about Ukraine. I mean, that's an incredibly positive role that you clearly are already playing. It was just a point of information, really, for me. In terms of other countries, do you play a role in advising the FCDO and the Department for Business and Trade, following any discussions you have in other countries about the state of rule of law in those countries?
Well, it's obviously a matter for an individual country to make its own government and form its own decisions. But we do, I think, provide some thought leadership, and that in fact is in terms what the Prime Minister has asked me to do in the Ukraine context. And I do think that's a role for a nation such as ours, which has a proud and strong legal tradition. We have really good international lawyers who operate in many fora across the world, to provide some thought leadership, while of course not telling other countries how to run their affairs. I'd be very happy, I know we're under time pressure, to pick up with any member of the committee, particularly on Ukraine, because that of course is where the rule of law is very much at risk at the moment, but there are other areas around the world that we haven't really got time to go into.
Lord Anderson.
Very briefly, I think I can address my question simply to the Solicitor General. You indicated at the start that you do the unduly lenient sentences and also the consents to prosecute. My first question you might be able to answer very simply. What steps do you take to preclude government influence over your decisions? Well, we've seen, if I may say so, the admirable statement that you made about the Carrick case back in March. Yes. Perhaps that's your answer, but anything you'd like to add to that would be welcome. And then in relation to consents to prosecute, sometimes Parliament requires Attorney General's consent to prosecute as a sort of additional check. I just wonder, in practice, how useful that is. I mean, are there cases where you either reverse a decision that the DPP has come to, or where it's pretty marginal and it's a good thing that you've been involved?
Thank you for those questions. I don't exclusively undertake the ULS scheme because, of course, where there's a constituency conflict or where for occasional reasons I'm unavailable, the attorney, of course, and that's the advantage of having two law officers, frankly, because there will be constituency conflicts, and it's right and proper that I don't deal with those personally. But the vast majority I do deal with. I don't think there is the sort of pressure that you referred to, Lord Anderson. There is political pressure rather than government pressure, I think. And perhaps if there's a particular constituency case where colleagues are concerned and that's been raised with them, that of course is a pressure, and a huge pressure. And it's occasionally raised by the opposition as well. So I think those are the pressures rather than government pressure per se. But it's very much not a political decision, any of these. It's very much a legal decision, a quasi-judicial decision, if you like. We're looking at it as lawyers and almost as judges rather than as politicians. And actually I found it fairly easy to step back into my non-political role and almost step back into chambers and examine the brief and see where the merits lie or they don't lie. In terms of cases, I agree with the attorney's previous point. There will occasionally be time where it will be appropriate to test the Court of Appeal's view from time to time, but only where appropriate. And the Court of Appeal is very quick to comment, and comment quite robustly where a case is before it, and the Court of Appeal has not thought it to be worthwhile. So that's on the unduly lenient sense. You mentioned consents to prosecute. I actually think there is a strength and a benefit in the attorney having oversight. It's cases such as under the Official Secrets Act, for example, Terrorism Act offences, explosive substances and the like, some more obscure than others. But I think there is an advantage in the attorney having an oversight of that. Specifically, yes, I have occasionally come to a different view. I'm bound to say it's rare, and more often than not, when the papers are before me, it's, dare I say it, relatively straightforward. But from time to time, I have come to a different view, and I have said no. Not invariably, but sometimes when that happens, my preference when that happens is to have a conference. And to invite those who drafted the papers, those whether in the CPS or elsewhere, to come into the AGO, and we'll have a conference and a discussion. But at the end of the day, it's the attorney and my decision. And yes, I have said no from time to time. Thank you.
Well, we're right up against our time limit. You're busy people, and I think we must